Thank you, Liz. And again, thank you to the Westhampton Beach Library. And thank you to all of you for joining us. I'm going to start with two things. One is a spoiler alert and the other is a disclaimer. Spoiler alert, estate planning in 22 is not all that different from estate planning in the past, because all the things we thought might change in terms of laws and the government, none of it's actually changed really when it comes to estate planning. So that's our spoiler alert. And in terms of a disclaimer, I just like to add at the beginning of these that this is not meant to be legal advice. So we're going to talk about a lot of different topics today. They may or may not apply to your individual situation, and they will certainly apply differently to each person listening today. So this talk should not take the place of a consultation or a conversation with your own attorney and other advisors. So getting those out of the way, we will start now with 2022 estate planning. So I just want to say, for those who were doing estate planning in 2021 because they were concerned about the estate tax exemptions going down and drastic changes based on changes in federal law at the end of 2021, none of those laws changed. The exemptions didn't go down in the end. There was no elimination of capital gains basis. We're going to talk about that a little more. So my advice to those who did rushed planning to get assets out of their taxable estate in 2021 is go back to your attorney now. It's 2022. You can take a breath. You can look at what you did last year and you can determine if there are changes that should be made or if everything is just good as is. But it's a good idea to go back and look again at what you've done in that might have felt rushed last year. Let's start at the very beginning in terms of what is a will, what is a trust, and how do you decide between the two or what you need. So when a person comes in to see us, we talk about three main areas: probate, taxes, and asset protection. When we talk about probate, we're talking about whether or not your last will and testament has to go through a court process in order for the terms of it to be followed and for your executor to be appointed by the court. All wills go through probate, and probate requires that there be a will. If there is no will, there's a different process called administration with the courts. Your will go through probate if you have any assets in your sole name without a beneficiary. So for example, if you have a checking account that's in just your name with $100,000 in it, your will have to be probated in order to determine where that $100,000 will go. Because if somebody went to the bank to collect that $100,000 at your death, the bank would say, there's no beneficiary on this, there's no joint owner on this, we don't know what to do with this account. And if you gave them the will saying, well, look, I'm the beneficiary of the will, they would say, you don't have legal authority to collect the assets from the will until an executor is appointed through the probate process, and that executor handles the estate. So when we look at whether or not having a will is sufficient for your estate plan, or if you need additional planning, we look at whether or not avoiding probate would be beneficial to you or your beneficiaries. So there's a few main reasons why we avoid probate. One is if you're concerned that after your death, there's going to be a big delay. So unfortunately, what we've learned over the past 2 years, and with the closing of the courts and the eventual reopening but slow down of court process, is that probate takes time. If you are, your primary residence is out in Suffolk County, it may go a little quicker than if your primary residence is in the city somewhere. We're finding probate's a lot slower in Brooklyn, in New York County, and Queens than it is out on Long Island, but it's still slower than it was. And so if you want your beneficiaries to have a quicker access to the assets in your estate, the time delay is one reason you might want to avoid probate. Another reason you might want to avoid probate is if you own assets in multiple states. So take somebody who has their primary residence here in New York, but they own a condo in Florida, or a small home up in Massachusetts or some other state where they go skiing or something like that. Anywhere where you own property, you're going to have to probate your will. So if somebody is in New York and that's their primary residence, the will would have to be probated here. And then an ancillary probate, we call it, would have to happen in that other state. So if you own the place here, the place in Florida, and the place up in Vermont or Massachusetts, you're going to have to probate in all 3 states unless we avoid probate, unless we make it so that those assets are not in your sole name without a beneficiary. Some other reasons we avoid probate: if you have a disabled beneficiary, that can slow things down and be more expensive to go through the probate process if there's a disabled beneficiary. And if you don't know who your next of kin are. So the probate process requires that your legal next of kin, we call them distributees, those who would take from you if you had no will, so the default provisions, you need to determine who those people are and they need to receive notice of probate. So when I have someone who comes in and says, I have no family, and my response is, everybody does. It's just how far off do we have to go? How far out of in your family tree? How many branches out in your family tree do we have to go to find someone? And if it's very far out and it's individuals who you maybe don't know, haven't seen in 30 years, don't like, are disinheriting on purpose, you're going to want to avoid the probate process, because you're going to want to avoid that person receiving notification that your will is going through probate and that they're disinherited. And so, my famous example was someone came to us, 2 individuals, they were the executors in a will. We did not know their friend when he was alive. Another lawyer did their will. And it was time he had passed away, and they came in and they said, he has this one account, it's $500,000. How do we get it? Well, we have to probate the will because there were no beneficiaries named. And what did probate look like for him? Well, he was unmarried. He had no children. He had no siblings. His parents were deceased. His next of kin presumably were on the first cousin or maybe second cousin level. And he didn't know who they were when he was alive. Certainly his friends didn't know who they were after his death. His parents were born overseas in 2 separate countries and, during wartime, and there was no record of who his family was. Probate was incredibly long. It was incredibly expensive just to notify these next of kin. So in that case, he would have been served well to avoid probate. The last reason that we like to avoid probate is if your will says that a trust is created for the benefit of a spouse or of a child, which we often recommend, we often want to avoid probate in those situations, because if the trust is created by the will, then any change in trustee or anything with that trust moving forward, you have to go back to the surrogate's court that the probate went through to have changes. So say your spouse is the beneficiary of a trust and you're doing it for tax planning purposes. Well, fast forward 10 years, your spouse can't be their own trustee anymore. They need a successor trustee or a co-trustee. They have to go back to the court to petition for that extra trustee. And so it's a lot more process if you are going to have these continuing trusts. So those are all the reasons we want to avoid probate, but how do we avoid probate? So depending on your circumstance, in some cases, we name beneficiaries on accounts. In other circumstances, we name a joint owner on an account. And yet in other circumstances, we recommend creating a trust and having assets be owned by the trust, therefore avoiding probate. Because remember, I said, probate is the process of putting your will through the court for approval if assets are in your sole name with no beneficiary. So if you title assets while you are living in the name of your trust, then they're not in your sole name. They are in the name of the trust. And therefore, upon your death, the terms of the trust document dictate where that goes without court intervention. Many clients like to do this. Probate avoidance is one reason that we create trusts. Another reason that we create a trust while someone is living is if we're looking for Medicaid asset protection for someone to be able to apply for home care or nursing home care Medicaid to cover the cost of their care. And some people create trusts for tax reasons because they're trying to move assets out of their taxable estate to avoid a big tax for their beneficiaries. So when we talk about each of those reasons why we would create a trust, we talked about probate avoidance. Now let's talk about Medicaid. If somebody needs to apply for Medicaid services to cover the cost of care, they have to have less than $16,800 in their name. Very often individuals want to take certain assets and put them into an irrevocable trust for Medicaid asset protection so that they can make sure that there are assets preserved to pass on to beneficiaries at the time of their death and that their assets aren't eaten up by the costs of their care. Very often, these trusts will allow the creator of the trust to get any income benefits from the assets in the trust, but they cannot receive principal. So if I put $100,000 in that trust, I can't expect to need that $100,000 during my lifetime because Medicaid would say, well, if you have access to that, then go ahead and access it and take that money out. And we don't want that. We want that asset to be protected. So an irrevocable trust for Medicaid asset protection will allow you often to have the income, but not the principal. We often also create trusts for your primary residence, for your home, co-op, condo, freestanding house. Why? Well, because while Medicaid says that while you're receiving home care Medicaid, you can own a home, any asset that goes through probate, so remember, sole name, no beneficiary, any asset that goes through probate, Medicaid can put a lien on it after your death. So to avoid that clawback from Medicaid, we very often will put assets into a trust so that it is protected. Even if it was protected on the eligibility side, we want to protect it on the after death clawback side as well. The third reason that I said why many people create trusts is tax avoidance. So estate taxes. Now I'm going to give you the numbers for this year for estate tax avoidance. If an individual has more than $12.06 million in 2022, when they die, they have a taxable estate. This does not apply to many people. So if you're an individual and you have $2 million, there is not going to be an estate tax because you're underneath the 12.06 million. The federal government, that's a lifetime exemption. So that means in life and death, I can give away 12.06. So if last year I gave away 10 million, but when I die, I have 3 million, well, then my estate, my lifetime is 13, and now I'm over the 12.06 and there would be a tax. The federal government allows you to give $16,000 a year, and that number went up from $15,000 last year to $16,000 this year. $16,000 a year gift tax free. So what does that mean? So if I have $16,000 that I give to each person on this webinar today, I can give you each $16,000, no taxes, no tax filings. If I give each person on this webinar $20,000 this year, well, then I've given to each of you a $4,000 taxable gift. I will file a gift tax return for that $4,000 per person. And whatever that adds up to be, when I die, that will be a placeholder against my lifetime exemption. So if I die in 2022, then each of those $4,000 gifts, when added up, will go towards my 12.06 million. So for those that don't have a federal taxable estate, they get, a lot of times clients come to us and they say, well, I know I can give 16,000, or it used to be 15, But the answer is, sure, you can give it. It might be a total red herring for your estate, because if you don't have even close to a taxable estate, then it probably won't be an issue. The reason I point that out is because with Medicaid, we have that 5-year look back for nursing home care. What does that mean? That means that if I need Medicaid to pay for my nursing home, from that date, they go back 5 years and they say, what did I give away in the last 5 years that will create a penalty? And therefore, that's time that Medicaid won't pay for my care. So clients often say to me, well, or my mother only gave away the IRS gift exclusion amount. That's all well and good for taxes, which may not even matter in mom's estate, but it is not sufficient for Medicaid purposes. Medicaid doesn't have an allowable gifting rule. You are not allowed to gift within that 5 years of needing a nursing home for Medicaid purposes. So it's very important to realize, again, this is why the personal advice is important, which of these rules applies to you and which doesn't. So you may know there's a $16,000 gift tax exemption every year, but what does that really mean and how does that really apply? I want to also point out that while it is $12.06 million this year as the estate tax exemption, Washington could always legislate and bring that down to a lower number. And the number in the year that you die is the number that's relevant to your own estate. But also the current law that was signed while Donald Trump was president states that that 12.06 million number is going to sunset on January 1 of 2026. So what that means is that for those that die until the end of 2025 are going to have this elevated number. However, if you die after January 1 of 2026, will have an exemption amount that will be closer to about 6 million, because the 6 million number will be the new exemption amount once the law comes. So for those that are younger and anticipate that they will be living beyond 2025, it's important to do your estate planning based on the lower number, not based on this $12 million number that may not apply in your case. The 6 million number is interesting because that's also right around where the New York State exemption is. New York State's estate tax exemption is 6.11 million. So again, if you have under 6.11 million when you die, you have no estate tax in New York. You've got a few issues in New York. One is that on the federal side, you have what's called portability between spouses. So if I have $2 million and my spouse has $10 million, then on the federal side, if I die first, my spouse can file an estate tax return and elect portability. That means that my spouse is saying to the IRS, Britt only had $2 million, but she had a $12 million exemption. I want the 10 million that's left of her exemption. And when I die, I want whatever my own exemption is going to be, plus I want Britt's 10. Therefore, if when my spouse dies, they have, even if it's after 2026, say they have a 6 million exemption, they've got 10 left from me. That's $16 million that they can have at death without there being any taxes. So it's great. We can share those exemptions between spouses. We run into an issue with that in New York for a few reasons. One is we don't have portability. It's use it or lose it in New York. So if I die and I only have $2 million, it doesn't matter that my exemption this year is 6.11 million. My other 4.11 is just lost. My spouse doesn't get the benefit of it when they die. The heirs don't. So often we do tax planning in order to make sure we're using as much of my exemption as we possibly can to balance it amongst the two spouses. So we don't have portability in New York. The other thing we have in New York, which is really hard for people to wrap their head around, is what we call a cliff. We have an estate tax cliff. cliff. So what it is you can think about, you climb up the mountain, right? And there's no tax, no tax, no tax. 6.11 is our exemption amount. And once you hit 105% of that, which is about a little over 6.4 million, you fall off the cliff. So you hit the peak and then you fall off. And what does that mean? That means that when you have over that 6.4 million, you're taxed back from $1. There is no exemption at all. So it goes from zero tax to over $500,000 of tax just by tipping over that cliff. So again, if you are someone who's getting close to that cliff amount, you may want to be doing some types of planning to make sure that your estate stays under that amount, because it could very quickly turn into a very large tax for your beneficiaries. Another thing that didn't happen last year, but that we're keeping an eye on in the future, is there was a lot of talk of a loss of a capital gains step up at death. So what is that? Capital gains tax is a type of income tax that is charged at the sale of an asset that has grown in value. So I like to say, if I bought a stock for $1, and when I sell it, it's worth $100, I have $99 worth of gain, and I have to pay a tax on the fact that I have an asset that has grown that much over the time that I've owned it. There was talk federally last year of losing a step up at death. So take that same $1 stock. If I hold on to it my entire life, and when I die, it's worth $100, and I pass it on to my child inherits it with a stepped up basis, meaning with my $100 date of death basis. So whereas if I sold it during life, I would pay tax on that gain. If my child sells it after my death, their gain is based on a bottom number of $100. So if they turn around and sell it right away, there will be no tax, no capital gains tax to my child on that growth. That's a huge benefit to people. So we see it a lot of times with properties. We see it on the East End. We see it in Brooklyn. People who bought properties for a very small amount of money. And because of the way the real estate market in downstate New York has gone over the past 20, 30, 40, 50 years, there's people who bought properties for $10,000 that are worth $4 million now. That's a huge gain. And you sell it during your life, you pay a capital gains tax. You sell it after death, we've stepped up the basis, and then there isn't going to be a tax owed. That's a huge benefit to our beneficiaries. So we still have that benefit. It's just something we're keeping an eye on because Washington has talked about taking that away. That kind of covers our tax issues, and I'm going to be happy to take questions at the end. I'm just going to go through all the topics and then open up for whatever questions anyone has. Another thing I want to point out about 2022 estate planning are planning with retirement accounts. A lot of people don't realize that as of January 1, 2020, a law called the Secure Act went into effect. And among other changes that it created to those with retirement plans contributing to a retirement plans, also for employers opening retirement plans for their employees. One of the big changes in terms of death and estate planning is that when you leave retirement accounts to your beneficiaries now, other than a few exempt beneficiaries, which include your spouse, your beneficiary is forced to take a 10-year payout. So take the individual who has $1 million in an IRA, a traditional IRA, and they named their daughter as beneficiary. It used to be that when parent died, leaving asset to daughter could take a stretch, meaning the asset got rolled over into an inherited IRA, and daughter took distributions based on her life expectancy as determined by the IRS. Obviously, daughter's life expectancy is a lot longer than parents' life expectancy. And so it continued to grow tax deferred. What we now see is that daughter is only allowed to take a 10-year payout. So daughter can still roll that asset into an inherited IRA, but by the end of the 10th year, that must be a fully distributed account, which means that that $1 million is additional income to the daughter over the course of those 10 years. And so a lot of people are looking at who they've named as beneficiary of retirement accounts, how they spend their retirement accounts, and some people are tweaking their plan based upon this new law. I will tell you, many people are not changing their plan based on this new law. Again, this goes in the category of get your individualized advice, because you may look at this with your accountant, your financial advisor, and your lawyer and say, you know what, we're going to keep taking our required minimum distributions. I'm very comfortable with that. And while my daughter might have to pay some more taxes, you know, good, she's going to have $1 million retirement account. So I'm okay with that. Whereas other clients of mine are either drawing down a little more aggressively while they're alive and in order to stretch the taxes out throughout their lifetime a little more. Some, if they have charitable beneficiaries, are choosing to leave tax deferred retirement to charities in whole or in part. Some are doing conversions to Roth IRAs. Some are using those larger distributions that they're taking and buying life insurance or long-term care insurance, depending on their age, their health, and all the other factors that go into that. And some are changing the beneficiaries to be one of those categories of beneficiaries that get the lifetime stretch. So someone who's not more than 10 years younger than you can get the stretch. So think a sibling or a friend who maybe you were leaving something to, they would get a stretch, which could potentially be more than the 10-year payout. A spouse, disabled child, not grandchild or other unrelated person, but if it's the child of the IRA owner, and they're disabled, they can. So there's different planning that can be done. And again, this may not actually result in a change in your plan, but it's definitely worth looking at and analyzing to make sure if there isn't a more efficient way of getting your assets to your beneficiaries. The other thing that I want to point out is that in June of 2021, we had implemented a new power of attorney law in New York. It was set to simplify the power of attorney. We previously had a power of attorney with a statutory gifts rider that allowed for transfer of assets, creation of trusts, etc. Those same provisions need to still be in the document, but they're done so in one document, just a power of attorney, no rider attached. And so if you have a power of attorney from before June of 2021, you might want to have it reviewed just to make sure it still complies with what you want it to comply with, that it's still going to do what you want it to do. Another thing that we've unfortunately seen in 2021 that, again, if you're looking at your power of attorney, you might want to pay attention to is if you have more than one person serving at a time as agent under your power of attorney, you'll see that on the document, there's a place where you could have, when you originally signed it, initialed for your agents to have separate authority to act. I describe it as an either or. And what we found with some banks in 2021 is clients have contacted us and said, the bank is now saying we have to be able to act either or. We cannot be forced to act together. And if we're forced to act together, the bank doesn't want to accept the power of attorney. We've seen this happen more and more, unfortunately, recently. And, you know, for some clients, you can fight the bank, but a lot of clients don't want to take that on. And so I think that if you have your agents acting together, you may have a very good reason to do it. You just might want to learn about the pros and cons in your case of having that set that way. The last thing I want to mention are items to watch. So I already mentioned that we're watching what is going to happen with the capital gains. We're watching to see if they're going to lower the federal estate tax exemptions before the law actually sunsets. We want to watch a few things with Medicaid. There are going to be changes implemented in how people are assessed for the level of care they'll receive. It was supposed to go into effect March 1st. That's now changed to May 1st, and it's unclear if it will be pushed back again. You may have heard that a 2.5-year look back was coming for the transfer of assets regarding home care Medicaid. We had first said October 2020, then we said January 2021, and we keep pushing it back. The current status is that it will not happen before July 1 of 2022, but even then it's unclear if it will ever come into play because the federal government, the CMS, the Center for Medicaid and Medicare Services, hasn't approved it. So we're watching that in 2022 to see if transfer of assets become necessary in terms of home care Medicaid, to do that in advance. And the last thing that I would say to keep an eye out for is the governor, in her current proposal for the budget for this year, has proposed to eliminate any asset test for Medicaid. So that would mean that when you apply for Medicaid, that $16,000 800 number that you have to stay under would not apply. It's very unclear exactly how this would be implemented. By its terms, it would not be implemented before January 1 of 2023. And it's unclear if it could even happen that quickly, but it's something we're watching and waiting. We should have more information when the budget is due, which, an on-time budget is by April 1st. So we should have more information then, and then we'll continue to watch it as it unfolds. So that's an overview of estate planning in 2022, which, as I said at the beginning, is very similar to prior estate planning years, but it's important to see what's coming on the horizon, what has been proposed, and where you might want to keep an eye on things or make potential changes based on recent changes in the law. So thank you to everybody. I'm happy to answer any questions. We have a Q&A at the bottom, if you're on a computer, at the bottom of the screen. So feel free to type that in, questions in there, and I'm happy to answer.
One question already. Thanks, Britt. So if all of my accounts have a beneficiary or joint ownership, do I need a will or a trust, or just each account go to beneficiary or joint owner?
So that's a really good question. I'm going to take it in two parts. The first thing I'll say is that, yes, if all of your accounts have a joint owner or a beneficiary, then there will not be a reason for a trust or a will to be involved. However, you want to make sure and get advice on your estate to determine if that is the best way for your estate to pass. So I'll give you an example. I had someone who came in and had named amongst 20 different people, different beneficiaries on all of the accounts. And the problem was there was no money in the estate for an executor or other appointed person to clean out the apartment, to pay final estate taxes, and handle different things of closing up the person's life. So in that case, all the money went out to various different people. There was no one in charge. So if all of your beneficiaries and joint owners are all going to the one person who's also going to clean out your home and make sure things are handled, well, then in that case, that might be okay. But in certain cases, you might want there to be money to go through an estate so that your final debts and expenses and property can be dealt with. The next question is about the $16,000 gift tax. So it's $16,000 that I can give to any one person. And if I have a spouse, my spouse can also give $16,000. So it's a total of $32,000 for the couple. But I could give $16,000 to as many people as I want, but it's $16,000 per person.
So if you'd like to contact us directly, you can check us out on our website at burnerlaw.com, or you can email us at info@burnerlaw.
But again, thank you everyone for joining us. I hope you found this informative. And we hope to come back and speak to everybody at the Westhampton Beach Library soon.